Our jury's out. You're welcome to be seated. Ms. Moss, the jury has found you guilty of all counts contained in the indictment against you. As you know, the state is seeking the death penalty, so this case moves into a second phase, sometimes called the penalty phase. Before we do that, there is one more step in the unified appeal process to review. Sentencing phase under the Uniform Superior Court Rule 34, Section 3B1. Before the commencement of the sentencing phase, all pending motions shall be heard. I believe that all have been heard. Are you aware of any that are not resolved, Mr. Porter? No. Ms. Moss? No, Your Honor. The court shall review Part 4 of the checklist with defense counsel and the prosecuting attorney. Count 4 of the checklist is as follows. 4A, opening statements. Opening statements are required upon request of either side, and we'll come back to that here in just a few minutes. Part B, issues that may be raised regarding the admissibility of evidence is another topic for consideration. Part C is issues concerning concerning specific statutory aggravating circumstances pursuant to OCGA Section 171030B. Section D is issues that might arise in connection with closing arguments. Section E is issues that might arise in connection with the court's charge. Section F is issues that might arise in connection with the verdict. And those are all of the Part 4 checklist items. The state, I know, is very familiar with it. Ms. Moss, you've had a chance to review it. Do you understand Part 4 of the checklist and the issues that I've just reviewed that might come up during the penalty phase of this trial?
Yes, sir, Your Honor.
Defense counsel, in this case you, Ms. Moss, shall be given the opportunity to raise in limine any objection to the state's anticipated evidence in aggravation. However, you should understand that a failure to object in limine shall not amount to a waiver of otherwise timely objections to the introduction of evidence. The court shall give the prosecuting attorney and defense counsel an opportunity to present any stipulations to which they have agreed. Mr. Porter, are you aware of any stipulations that may have been entered into with you and the defense?
No, Your Honor.
Okay. Ms. Moss, do you have any motions in limine or objections you'd like to voice about anticipated aggravation evidence that might be presented by the state?
Yes, sir, Your Honor.
The third Part C option with respect to this particular inquiry that the court has to make deals with retrials as to sentencing, which is not applicable in this particular case. All right, when we resume, there's a brief introductory piece of information that the court is going to go ahead and give to the jury from the pattern charge book. Then I'll offer each side the opportunity to give any opening statements that they might like if they wish to. And then we'll move into the state's evidence in aggravation, followed by the defendant's evidence in mitigation. Is the state ready to proceed?
State's ready, Your Honor.
Is the defense ready to proceed? Please bring our jury. You can be seated. Thank you very much. Welcome back, ladies and gentlemen. Members of the jury, under the procedures followed in Georgia, criminal trials are conducted in 2 stages in certain felony cases. In the first stage, the jury determines the guilt or innocence of the accused. If the jury determines that the accused is guilty, then the state and the accused both have a right to submit additional evidence in aggravation or in extenuation and mitigation of the punishment to be imposed. After hearing any such evidence and argument, if any, the jury then retires to again consider the sentence and to determine the punishment to be imposed. The penalty set must, of course, be within the limits set by law, and I will give you those limits at the appropriate time.